right there. So now we have another verdict, another family member. Joining me in the studio is criminal defense attorney Sarena Townsend. We're going to chat about this. We're still talking, so that's good. We haven't come to blows yet over topics. Let's talk about trial 1 versus trial 2. Sure. Jennifer Crumley took the stand. Let's just say her attorney was less orthodox. That's probably the nicest way I can say it to Ms. Lehman, who represented James Crumley here. Give me your take on the various differences in the two trials. Same outcome, but still.
Same outcome. A little bit of a scary outcome, I think, for all parents around the world here. But most criminal defense attorneys will advise their client not to take the stand. It is too risky. They're opening themselves up to a lot of cross-examination that they may or may not be prepared for. And frankly, it's a nerve-wracking experience enough already. But once you're on that stand, knowing that those questions are coming and you may not have the right answers, it's never a good idea unless you know for sure, you have an alibi, you weren't at the crime scene, or there's just some slam dunk evidence that you could provide to a jury to convince them that you are not guilty. Here, a very risky choice to put somebody on the stand, especially knowing that there was some evidence showing culpability, including text messages, social media posts. You don't want to open yourself up to the kind of cross-examination that she opened herself up to.
So let me ask you this, and we don't know one another, just met. I'm going to hang it out there. I have no political affiliations. I think if any politician on any side of the aisle, color, stripe, or persuasion ever does anything that helps me or my family, it's total accident. So I have no affinity to any politician. So I'm looking at the process here. Sure. This is a cop-out to me. It's a cop-out. He basically had a tough decision to make, and I've never really seen the column A, column B process of coming to a decision. He's basically said, Fonnie Willis, you can, on your own, withdraw, or you can kick your now former boyfriend off the case. Give me your thoughts.
Yeah, it's an interesting concept. It's kind of like a splitting the baby situation, but also allowing the DA to make that decision herself instead of the judge making a ruling on this. And so it is interesting. They obviously feel like there's some sort of appearance of impropriety, which is a huge problem. But they're not willing to take the extreme step of actually taking the DA off of the case, allowing her to make that decision herself. Obviously, the more strategic decision for her to make is, I'm going to stay on, and the ex-boyfriend's going to go.
I'm pretty sure that's what's going to happen. I mean, if nothing else, she's guilty of first-degree arrogance. And so I don't think that she's just going to say, you're right, I made a little mistake, I'm out of here. It's going to be, wait, who?
Right.
Okay, so let me ask you this about the other reference the court makes to the ethics committee.